Next, we're going to turn the table over to Marnie Farron, Jean-Paul Bradshaw, and Eric Yaffe to talk about white-collar issues and trends in the white-collar area. Really looking forward to this presentation. Eric, Marnie, and Jean-Paul, take it away.
Thanks, Brian. I'm Jean-Paul Bradshaw. I'm happy to be with you this afternoon. As the slide says, I served as the United States Attorney from 1989 to 1993, and in that role served as the Chief Law Enforcement Officer for the Western District of Missouri. And we're going to talk about, most of what we're going to talk about today are matters that flowed at one time or another through that office. Since coming out of the U.S. Attorney's Office in 1993, my practices include doing internal investigations and really any kind of litigation that's related to the government. So it could be white-collar criminal defense work, False Claims Act, or sometimes called qui tam lawsuits, regulatory suits, grand juries, administrative subpoenas, and I think one of the more fun areas, and that's representing companies or individuals who have been victims of fraud and being able to kind of help them find the right avenues to find recovery. Today, I'm joined by by two of my colleagues, Marnie Farron, who is in our Minneapolis office, and Eric Yaffe, who's in our DC office. Both Marnie and Eric will tell you about their backgrounds, but very similar experience and practices to mine. And it's really been one of the benefits of the combination between Lathrop and Gray Plant Moody, and that is being able to really build a strong depth in this practice area. In addition to the three of us, there are a number of other attorneys that practice in this area, and it really gives us a very strong bench and the ability to do some work that neither firm could do probably as well before. Today, we're going to touch on a number of topics that we believe are relevant to most companies. Eric's going to start us off talking about voluntary requests from the government, civil investigative demands. With Marnie, the heat goes up a little bit with more of the compulsory process with search warrants and grand jury subpoenas. And I'm going to come back at the end with a little bit of a crystal ball about the election and what that means for government enforcement in the areas that we're going to talk about. Does it really make a difference about which person occupies the White House when it comes down to criminal and other government regulatory enforcement? And we hope to leave a little bit of time to get to some questions at the end. So Brian mentioned earlier in the earlier presentation, we're doing polls in each of the presentations, and we're going to actually put ours up now because we'll take some of the results, and Eric and Marnie will address those as a part of their presentations. And that poll, when it comes up, there it is. Has the company for which you worked received a request for information or a subpoena from a state or federal government agency during the past 7 years? I wanted to ask, had anyone committed a crime, but we thought then you've got to have a Fifth Amendment button, and that would have created all sorts of issues, and we don't want to inquire. So we'll start off with this question, and with that, I'll turn it over to Eric.
Thanks very much, Jean-Paul. Again, this is Eric Yaffe. I'm in the Washington, D.C. office of Lathrop GPM. And to just supplement my bio very briefly, I spent 9 years as a federal prosecutor in Washington, D.C. with the Department of Justice, first as an assistant U.S. attorney in the U.S. Attorney's Office in D.C., where I prosecuted everything from burglaries and robberies, drug cases and homicides. And then after 5 years, I moved over to the Maine Department of Justice and was in the public integrity section, where I prosecuted public corruption cases around the country for 4 years. And in private practice now for several years, I've been on the white collar side, handling government investigations, internal investigations for companies, as well as cases brought against individuals and companies, both civilly and criminally. Well, with that, let me turn right into this. I would mention, by the way, at the outset that I am in the Watergate building today, which is where our offices are, but there have not been any burglaries today, at least, of our offices, which is great. So let me turn to voluntary requests for information first. Now, what happens? You get a request from the government voluntarily asking you to produce certain information or to make people available for interviews or depositions or even interrogatories, asking you to answer certain questions. And the first thing that might come to mind is, why is the government doing this voluntarily? Why are they not issuing a subpoena? Well, that's often because the government may not at this point have very much information and they simply want to get something out quickly. They might not want to go through the bureaucracy of getting authority for a subpoena, and they want to start out just by asking for information voluntarily, and it happens with some frequency. And of course, you're not compelled to produce information or to comply with this request by the government, except in certain limited situations. If you're in certain industries, such as an investment advisor, or you're in the brokerage industry. But generally speaking, you don't have to cooperate. So the question becomes, are you going to cooperate with the government in the first instance? And you may have reasons to cooperate. You may have reasons not to cooperate. You may not want to cooperate because the government is asking for private information concerning individuals within your company. You may not want to cooperate because they are asking for commercial information that you might deem very sensitive, or trade secret information. So there may be a variety of reasons for you to think about whether you want to voluntarily comply. On the other hand, you may want to cooperate. You don't necessarily want to be on the wrong side of the government, and you want to look as though there's no reason for you to hide anything, and that you're willing to go forward and provide information. But that's a threshold question that you're going to need to ask. If you decide to cooperate, then there are a number of things that you need to think about and do. You want to make sure you're going to gather the information in a methodical, thoughtful way and provide it to the government. You're probably going to want to have an individual within your company start out as the point person who's going to field questions and work with your inside or outside counsel. You're going to want to talk to your tech people internally, because you might need to get electronically stored information and produce that to the government. And you want to make sure you use the appropriate search terms. You want to make sure you understand who within the company are the custodians of this information, who holds the information. You don't want to necessarily go to every person and ask them for information, but you do need to make sure you're covering your bases. You probably want to do a litigation hold, which is there, since there's some concern that information could be inadvertently even destroyed or modified. You don't want that to happen. Certainly you don't want the government to think that you're destroying information. So you want to consider sending out right away a letter or an email to those people who might have the information. Make sure that they are preserving everything. Make sure your tech people are preserving everything, and that you eschew your usual document retention policies so that you don't inadvertently lose or destroy any information. You also want to make sure you and the government are on the same page. I think it's very important at the outset that you develop a relationship of trust with the government. You want the government to feel as though you are working with them, that you're cooperating, and you want to develop a good working relationship with the government. Oftentimes the government will be asking for the world in its initial request for information, and you will want to consider narrowing the government's request. That means maybe working with the government, trying to find out initially, what is the government looking for? What is this investigation about? And do they really need all this information? And you also want to try to find out how your company is or is not implicated potentially by this investigation. Are they a target of the investigation? That is the company the entity that the government is actually honing in on, and they really are looking to potentially bring charges against the company? Or are they what we call a subject of the investigation? That is, the government is interested in the company, doesn't really know whether or not the company is involved. Or is the company simply a witness? That is, it's a third party, the government is really looking at someone else or a different entity, and they're just looking for information from you to help them as against some other entity. So you really want to try to find out from the government as much as you can The government sometimes won't give you very much information, but you'd be surprised. Sometimes they will actually let you know a lot more than you might think they ordinarily would. When you ultimately respond to the government, you have to be very careful. You want to make sure that the government knows exactly what you are providing to it and what you're not providing to it. And you want to put that in a communication to make it very clear what you're providing to the government. You also want to make sure that to the extent you are providing any confidential information, confidential commercial information, or trade secret information, or information that may be protected by privacy, that you make it clear to the government that you want that information protected. You don't want a FOIA request to end up on the government's desk and the government simply turns the information over. And there are exceptions under FOIA, and the government does have a responsibility and usually will try to protect that information. On the other hand, you also want to make the government aware that it should notify you in the event that there is a FOIA request and someone is requesting information that could be confidential, especially a competitor of yours or others who you might not want to get their hands on that information. You also want to protect any privileged communications and information. Obviously, you don't want to provide any attorney-client privilege information because you might be waiving the privilege, in which case the government or others could get much more information that would and should be protected. So there are a lot of things that you need to think about, even with respect to a voluntary request. You got to think about whether, for example, you need a subject expert to help you with this inquiry. If it's a complex antitrust case or a complex medical or drug case, you might want to bring in experts to assist you. You want to determine whether you have insurance coverage for this, for obvious reasons. You also want to determine whether or not, as a result of an inquiry from the government, you have to disclose the information to third parties or even people internally. So you might need to disclose the information to your board of directors. You might need to disclose the fact of the investigation to your shareholders. Potentially to even vendors or insurers. You might have contracts that require you to let these parties know that there is a government investigation. All of these are considerations and things you need to think about whenever the government comes knocking on your door. Now, in addition to voluntary requests for information, there are also instances where the government may provide you with or issue what's known as a civil investigative demand, or an administrative subpoena. Most government agencies have the ability to subpoenaing you without getting court or other approval through those processes. And nevertheless, they have the backing of the court if need be. They can go to the court to enforce the civil investigative demand or administrative subpoena. And you want to go through the same kinds of processes that you go through when there's a voluntary request for information. But there are very specific statutes and regulations that govern CIDs and govern administrative subpoenas, which you'll want to take a look at if one of these is issued to your organization. So, for example, typically you'll have about 20 days to respond to one of these requests or civil investigative demands. And if you're going to move to modify or quash the CID or administrative subpoena, you have to do that quickly unless you're able to get an extension of time from the government. The government sometimes can ask through a CID or administrative subpoena, they can ask for interviews or depositions of your internal clients and can ask interrogatories as well. With respect to asking for depositions, they can do a forthwith basically CID or administrative subpoena that might ask that it be done within 7 days even. So you're going to have to be on your toes, be aware of the deadlines. You don't want to waive your rights and get an extension of time from the government if necessary to respond to these. I will say, though, that the power and authority of the government with respect to CIDs or administrative subpoenas is extremely broad. And generally speaking, if there is a lawful government objective and the information that the government is seeking from you is relevant or connected to that lawful objective, then it's highly likely the court will permit the CID to issue and will force you or compel you to produce the information or to make that witness available. It's very difficult to get a CID or an administrative subpoena quashed or modified. But there are over, I think, 300 statutes and regulations governing administrative subpoenas and CIDs. Again, almost every agency has the authority to issue those in connection with investigations. You may have to do your own internal investigation once you receive one of these to get your arms wrapped around issues, make sure you understand it, and to stay ahead of the government. And be in a position to better answer the government's questions and to defend the company's rights as well. And that's something else you'll need to consider, as well as in the event that certain individuals within your company may be implicated or potentially involved in the government's investigation or be a target, they might need separate counsel. You'll have to deal with them separately. And there's a whole other slew of issues in connection with dealing with those considerations, but you should keep that in mind as well. That's a very quick overview of voluntary requests for information and CIDs and administrative subpoenas. I'll turn it over to Marty to go into in some detail the more even serious issues that arise with search warrants and grand jury subpoenas. Marty?
Thank you, Eric. As Brian and Eric mentioned, and Jean Paul mentioned, my name is Marnie Farron. I'm in our Minneapolis office. I've been practicing law for about 20 years, and I've been in criminal defense most of that time. So I have faced the gamut of issues that my colleagues have with respect to administrative subpoenas, grand jury subpoenas, representing people who are prosecuted by the government, and dealing with related civil issues. So I am happy to be here. I have been asked to speak about two other tools that the government has in their toolbox when it comes to investigating, and that is search warrants and grand jury subpoenas. Both are compulsory. I'm going to start with search warrants, and you might be sitting there thinking, gosh, I don't need to worry about this. My company is never going to be the subject of a search warrant. And I can assure you that every client that I have represented in the last 20 years that has been the subject of the search warrant has thought the same thing. So our number one advice to you all is that you have a plan. Hopefully you're never going to have to use it, but we do suggest that you have a plan just in case. And the main goal of the plan and the way that you deal with the government is really to balance the interests, balance the company's interests and the interests of the individuals versus cooperating with the government. The first thing that we suggest you do is to designate a point person. That's going to be the person that's assigned to interface with the agents should they show up at your door. Everybody there should know who your point person is. That way, if it's an issue, they know who to notify. You should obtain a copy of the search warrant and the search warrant affidavit. The search warrant is what the judge signs that gives the agents the authority to come and search the premises. The affidavit is what is filed with the court giving the justification for the search warrant. It sort of describes the basis for the search warrant. You should also get the credentials of the lead agent. There will be an agent leading the search, and it will be important to get that person's name and contact information so that you can provide it to your counsel. It's important to take a look at the search warrant when you get it. Make sure, number one, just basic, that it's signed by a judge. Check to see where the agents are allowed to search. You might have multiple buildings at your premises. Does the search cover all of the buildings or just one of them? Are there any internal limitations to where the agents can search? Does it include vehicles? Does it include cell phones? Those are things to check. Also check what they're allowed to take. Are they allowed to take documents, computers, other tangible items? And look for any restrictions on timing. Sometimes there will be restrictions on the hour that they can execute the search, and you should make sure that the search is being conducted within those hours. And then notify in-house or outside counsel just as soon as you possibly can so that they can get involved and guide you through the process. You can dismiss non-essential employees. A search is very disruptive, and it can take hours. So you're going to want to dismiss non-essential employees. They're not going to get any work done anyway, and by dismissing employees, it does reduce the number of people that are on site and available for potential interview by the agents. And I'll talk a little bit more about that in a second. At the end, you should note any locations of attorney-client privilege materials. For example, if there's a particular file or a particular office that contains privileged materials, you should let the agents know that there are privileged materials in that location. There's also probably likely to be privileged materials on computers, and you should notify the agents of that as well. At the end of the search, you will get a search warrant inventory. The inventory is going to list what the agents took and where they took it from. So for example, if they take documents from the third office on the right, they're going to say what they took and that they got it from the third office on the right. And a minute ago, or a second ago, I should say, I mentioned employee interviews. The agents may try to interview employees who are on site. You should notify the employees of their right. They have the right to choose whether or not they want to participate in an interview. They have the right to consult with counsel prior to making that decision. What you should not do is tell the employees not to talk to the agents. You should not counsel them not to participate in an interview. That can be viewed as obstruction of justice. If an employee asks you if they should consent to an interview, don't tell them no, that you should not, but you can tell them, you can remind them of their rights, that they have the right to choose, and you can remind them that they have a right to decline the interview. That's okay. If you have employees that do participate in an interview, those employees should be re-interviewed. We should find out what kinds of questions they were asked and what kinds of answers they provided. We'd also like you to advise the employees to keep their confidences as much as possible, keep the information confidential, and to let you know if they receive a grand jury subpoena. Often, search warrants are either accompanied by or followed up shortly with a grand jury subpoena, a subpoena for documents. So we also recommend that you place a litigation hold following a search warrant just to preserve your documents. One other note about search warrants before I move on to grand jury subpoenas. Many times warrants will be executed in multiple places. For example, if the government reasonably believes that relevant documents are located in a home office, they may also, and sometimes simultaneously, execute a warrant at an individual's home. The same sort of guidelines and rules apply to a warrant executed at an individual's home. I would say that it's probably more likely that there would be restrictions on locations within the home that could be searched. And so that would be something to kind of take a look for if you are facing a search warrant at an individual's home. And next, I'm going to talk about grand jury subpoenas. And I'm going to start out just with a little bit of an overview. What is a grand jury? A grand jury is a sort of a mysterious body. It's a secretive body, so to speak. It's made up of 23 individuals in the federal system. It's a group of individuals. They meet monthly. They serve for about 18 months. They're pulled from voter registration lists, so you're just as likely to get jury duty to be on a federal grand jury as you are to get on a regular jury. And it's a body that investigates and charges crimes. And as part of that, they have the power to subpoena individuals to come and testify, and they have the power to subpoena documents. We saw a lull in grand jury activity when COVID first hit. But grand juries have resumed meeting, at least in some jurisdictions. I know in Minnesota, and I presume elsewhere as well. As I mentioned when I was talking about search warrants, grand jury subpoenas often accompany or follow search warrants. Initially, you're likely to see a grand jury subpoena requesting documents. Later, the government will likely subpoena employees to testify. But it's also really possible to receive a grand jury subpoena if you're not subject to a search warrant. In fact, it's much more likely that you will encounter a grand jury subpoena of some sort at some time than it is likely that you will be the subject of a search warrant. Anytime you get a grand jury subpoena, whether it's for documents or whether it's for one of your employees to provide testimony, it's really important to consult with criminal defense counsel. That's just because there's such a wide range of implications, a wide range of things that can happen after a grand jury subpoena is received, that you need to make sure that you're considering the response very carefully in light of those considerations. For example, if you receive a subpoena for documents, obviously you're going to have to consider the scope of your response, very similar to what Eric was talking about with respect to CIDs and voluntary disclosures. You really want to be clear about what you are providing. You want to be careful about the timing of your production. You want to ensure that the production is made in such a way as to protect the company's rights. There's also some benefit to establishing rapport with the agents or the prosecutor when you're responding to subpoenas. And so local criminal defense counsel in particular, who are familiar with the local players, can really be helpful in that regard. When you're faced with a subpoena for testimony, there's some additional things to consider. One of the big things is how the government classifies the individual, and that really informs you about how you want to proceed. Eric talked about this during his portion of the presentation. He talked about the three classifications being witness, target, and subject. Obviously, as he mentioned, target being somebody that the government intends to prosecute. Subject being somebody who's a really amorphous and squishy definition of somebody whose activities are within the scope of what the government is investigating. And that could be a whole host of people. And I'll give you an example. For example, you may have a medical device company that sells and that has salespeople that sell products. The government may allege that some of the marketing messaging is fraudulent or illegal in some way. The salespeople may not know that the messaging is illegal and may not be involved in creating the messaging, but they're delivering the messaging to the customers ultimately. And so they may not be a target of the investigation. The government may not believe that they have criminal responsibility, but what they're doing is certainly within the scope of what the government is investigating. So when you think about that in the context of a company, there are just so very many people that can be subjects of investigation. And finally, witnesses obviously are just as they sound. They're just people that have factual information that the government is interested in. But one thing to know about these classifications is they're not set in stone. The government can classify somebody as a target, of subject, or a witness, and that can be fluid. Those classifications can change. It's unlikely that a target would ultimately become a subject or a witness, but it's not unheard of. But it is possible that someone may move from a subject category to a witness category, or unfortunately, the other direction, from a witness or a subject to a target. And really, that is what we are trying to avoid. And that's one important reason to contact criminal defense counsel. The individual's classification also informs a couple of other things: whether separate counsel should be engaged for that particular individual, There are times when the interests of the individual don't necessarily align with the interests of the company, and whether that individual should exercise their Fifth Amendment right not to testify in front of the grand jury. As you can imagine, someone who is a target certainly should not be testifying in front of the grand jury, and should have separate counsel. There's obviously less risk if somebody is a witness, and a very thoughtful analysis should be undertaken when trying to determine whether somebody who is a subject should have separate counsel. I am going to not talk too much here about the grand jury process, but I want to give one anecdotal story before I end my portion to sort of underscore how important it is to ensure that you have appropriate counsel and consider appropriately how to proceed with a grand jury subpoena and whether to engage separate counsel. I represented a group of employees in a very large prosecution several years ago. Prior to one of the employees coming to me, he testified in front of the grand jury, and he was accompanied by company counsel. Presumably, the thought was that if the employee went into the grand jury and told the truth, that the government would conclude that there was no case and would decline to prosecute. What ended up happening is that the employee went into the grand jury and testified, and the employee's testimony did not align with the government's view of the world, as is quite frankly often the case. The government concluded that the employee was lying and actually ultimately brought perjury charges against that individual. The good news, there's sunshine at the end of the rainbow, or the rain, or whatever the saying goes, but at any rate, the charges against the employee ended up getting dismissed. But this wasn't until after a lot of time and a lot of money was spent on his defense. And quite frankly, if that employee had had their own separate counsel early on, there would have been somebody looking out just strictly for the rights and the interests of that individual, as opposed to the company as a whole, and he may have received some different advice. And so with that, I will turn it over to Jean Paul to look into his crystal ball and talk to us a little bit about the current environment and what we might see in terms of prosecutions going forward.
Thank you, Marnie. So there's 93 U.S. attorneys. Each federal judicial district has a United States attorney, and as the late Justice Scalia referred to them as little fiefdoms. And when you're told when you become a U.S. attorney that most of what you do is up to your call. When done properly, big capital P political considerations don't come into effect, and in my experience, that's been largely true. But you are part of the president's administration, and whether it's George H.W. Bush that I served with, or Clinton, or the other Bush, or President Obama, President Trump, each president comes in having run on a platform, a number of things that they want done. And part of that platform will include the Department of Justice and other agencies that have enforcement powers. And so what they emphasize, the big P political, it's fair for them to come in and say, well, I'm going to put a greater emphasis on drug enforcement, or I'm going to put a big emphasis on healthcare fraud or taxes, or whatever they want to say. And so when you come on board, you understand that there are these national priorities, but yet, with the exception of antitrust and civil rights, you largely can do what you want to do. But the Department of Justice has ways of making sure that you're towing the line to some degree and emphasizing the areas that the broad areas, not the specific cases, but the broad areas that the particular administration wants to emphasize. And they do this in a number of ways. Resources that are made available are a big thing. When I was in the office, financial fraud, and then later affirmative civil, that is pursuing civil cases for government fraud, were two big areas. And what did they do? They said, you know, they went to Congress and they got additional positions and then would dangle them out to the districts. And if you had the cases to justify it, then you could get additional positions. And there's also the peer pressure. You have meetings with your colleagues, your other U.S. attorneys around the country, and there's various mailings and such that are sent out, and some of your colleagues get recognized for forming, you know, a task force to deal whatever the crime du jour is. And, you know, U.S. attorneys are human like everybody else. They like the recognition. They like to feel as though they're kind of part of the team. And the attention they get from the Attorney General if their district has a pilot program dealing with one of the important areas. So even though, you know, what we do in Kansas City is going to be different than what they do on the border in San Diego, or what's being done in North Dakota, where they have a lot of tribal reservations, or what happens in Florida, which was a big area of import, or where Eric was in DC, where the seat of government. All those places are different, and they're going to have slightly different priorities, but the enforcement priorities are going to have impact on them. So what's that likely, you know, what are we likely to see in that regard? I mean, right now in the current administration, violent crime is a top priority, and we see it. Unfortunately, we've seen some headlines in Kansas City over the last couple of days. A little unfortunate mistake in citing statistics, but we're seeing examples of resources being made available to districts where it's viewed that they have a violent crime problem, or the Project Safe Neighborhood, which has been here in Kansas City for a couple of years now, looking at violent crime and how do we solve that. The opioid crisis has been a high priority. Human trafficking. If you're getting my kind of drift with this administration, it's been particularly on what I would say is human-related violent offenses, or that genre. We've seen some emphasis on elder crimes, crimes in which the elderly are made victims. I found it interesting. I was looking at the DOJ website, and they list environmental justice as an area. I think every administration puts that, but particularly in the area of agriculture, for example, this administration has been very friendly toward ag. And so some of the cases that we saw, I had a case involving a dairy farm up in Iowa for a case, you know, that one of the tough things about environmental is that depending upon the discretion of the prosecutor, it could be a criminal case, a civil case, or an administrative case with almost the same mens rea. And most environmental crimes don't require an intent beyond negligence or gross negligence. So that prosecutorial discretion, do I turn that into an administrative case, a civil case, or a criminal case, can vary greatly between administrations. And in this one, now's a good time if you're in the ag world and have a consent decree. It's a good time to hurry up and get in there and try to renegotiate that consent decree. Or it's a good time if you have an environmental problem to, you know, argue that it should be treated as an administrative or civil rather than a criminal offense. So these sorts of things that the administrations make priorities do matter when you get down to the individual cases. If we have an administration change in November, and I'm not making any predictions one way or the other, but there's at least a strong possibility that could occur. We look at both what Joe Biden has talked about a little bit. We kind of haven't gotten to that stage of the campaign where we've seen stronger specifics, but we could look at what the historical DOJ perspectives have been, or priorities have been in Democrat administrations. You'll see environmental enforcement jump way high on the list. You'll see healthcare fraud, both because you know there's always an effort to expand healthcare. Expanding healthcare means more money in it. We always say crime follows money, so you see more emphasis toward healthcare fraud, False Claims Act and key TAM cases. Often in the economics of pitching a program, they'll say in order to justify the cost, we're going to go out and bring in, we're going to crack down on fraud, whether it's tax fraud if somebody wants a tax cut, or healthcare fraud if they want more healthcare. And so there's emphasis on that. Economic business crimes, probably a sensitivity toward offenses that could disproportionately affect minority communities. And I think obviously the biggest area there is enforcement of certain drug offenses. And then a whole new area is that related to PPP. That's going to be a huge area. Once again, crime follows money. Follow the money and you find the crime. There's literally billions or not trillions of dollars placed in these programs. And what starts off as a grant can turn into, or starts off as a loan can turn into a grant. And there's all sorts of ways that fraud might be committed with respect to that. There's lots of regulations. And when you break a regulation, they can turn that into fraud. So I think both on the criminal side and also keep in mind, you could view these as claims for payment so they could come within the False Claims Act. You could see key TAM cases and criminal fraud, as well as the specific provisions that apply to that program. So I think what you're going to see is more of an emphasis on economic crimes of varying kinds, and probably less in the violent crime area. And probably for most people and most business and the businesses that you all work with, that's a more of a potential risk area than probably over the last 4 years. So with that, I'm done, and I will turn it back over to Brian Dillon. Thank you very much for listening.
And just real quickly before Brian jumps back on, the poll results, if anyone was wondering, is approximately 1/3 of you have received a subpoena, and about half of you don't know one way or the other. So people are doing a good job of keeping those confidential. So just good to keep in mind some of these tips, because I do think that a lot of people have experienced the situation. So Brian?
Marnie, thanks, Eric. Thanks, Jean Paul. I've never received a subpoena myself, but I know if I ever do, I know who to go to.